just want to take one step back and raise some of the issues, just wrap up on some of the issues that Mr. Ngalwana has raised, but in the context of situating the whole case.
Yeah.
So, my lord, the structure of this case is actually very simple, and I'm doing this really because from the reading of the answering affidavits and the heads, it is my respectful view that some of the respondents actually don't appreciate the nature of the case, and maybe that's our fault, so it's my obligation to just spend 2 or 3 minutes to explain. I say so because you'll find, my lord, and this is a criticism that we make, for example, of the JSC, as we say that 90% of them, that's obviously not a scientific estimate, of their focus is on this interim interdict.
Yeah.
Everyone out there is saying, you know, controversies when Dr. Hlophe are here to interdict. And we can understand why that seems to be the case. But the reality, my lord, is that this case, the interdictory relief, as your lordship pointed out to Mr. Ngalwana earlier, is actually the alternative. So this case cannot be about the alternative relief. The primary case that we bring here, my lord, is prayer 2, which is the declarator. And the reason why everybody is running away from the declarator in our respectful submission is because it's actually unanswerable. And you will find, my lord, that, in fact, it's interesting. FUL goes on for pages and pages trying to attack the declarator, but with no substance at all. The JSC takes the exact opposite. They just refer it in one sentence. They say, no, an interim interdict cannot, or rather, a declarator cannot be equal to interim relief. And that's it. That's the sum total of their defense to the declarator. The issue then, my lord, is this. If we then situate the case in its proper perspective, then your lordship will realize that all these pages and pages that have been spent here about balance of inconvenience, this and the other, the impact on the judiciary, and what have you, are actually completely irrelevant in the consideration of the relief that we come to seek here. They may become relevant, of course, if your lordship finds against us on the main relief, and then we have to interrogate the issue of the alternative relief sought. But you can't argue a case by turning it upside down and then saying, no, but the alternative relief is bad. But so what? Because we may never get there at all. So that's the first thing. The second thing, my lord, that I want to say by way of prefacing is that now, if we then focus on the real case, which is the declarator, how Mr. Ngalwana's section and mine combined is as follows, and your lordship again foreshadowed this by a question a few minutes ago. So Mr. Ngalwana's primary focus on the interpretation point is that the constitutional impact of the Western Cape High Court order is that, and its proper interpretation is that it taints all 6. And he has made submissions. The lordship has interacted with him. There's no point in belaboring that. We agree, obviously, with that. Our focus on the interpretation point, my lord, is that even if Mr. Ngalwana's interpretation is incorrect, the absence of Dr. Hlophe alone has the same constitutional impact, the same nullifying impact on the composition, and I'll develop that point now. Now, some of the indications, my lord, of the just to wrap up, if your Lordship goes to the paragraph that Mr. Ngalwana read, paragraph 64, you'll find that at 02-69 of the judgment, my Lord.
Yes, paragraph 64, you say?
Yes, paragraph 64, my Lord. In addition to all the other indications that Mr. Ngalwana indicated, that this is a designation of the delegation per se, and I'll explain how I use that word as shorthand. You'll see that even it is evident from the papers that the NA failed to appreciate that it had a discretion in designating MPs in plural. So that's really the crux of the interpretational exercise. So, my Lord, I use what you call a collective noun, say a flock of birds and so on. So, for shorthand, the collective noun we have to use for this is a delegation of designees.
Yeah.
Correct. Thank you, my Lord. Then that's going to assist us. So, if we look at it like that, we say what the NA was doing was to pass a resolution, one resolution, for a delegation of the designees per se. Then that's the end of Mr. Ngalwana's point. It's very clear. And if that is so, my Lord, if this is a delegation or a squad or a team, whichever collective noun you want to use.
No, we settled on delegations.
Delegation.
I'm happy with that.
I'm happy with that, my Lord.
Yeah.
Yes, because I saw in some dictionary there were like 70 of them, a swarm of this and a gang of this. But nothing delegation will do. Yeah. Thank you, my Lord. Now, if we accept that, then, my Lord, it creates the following two problems. And I'll raise this in relation to the SCA cases. Remember, there's this whole debate about the SCA cases and the court and the full court here.
Mm. Are you referring to the full court decision
in
this division about whether Dr. Hlophe in a previous guise was essential?
Yes.
Was an essential attendee at the JSC?
Yes.
Thank you.
No, in fact, it was raised by him, my Lord, to say that the absence of the president or deputy president of the SCA.
Oh, I'm sorry. Yes, no, that's correct.
That's the one.
That's
Sutherland TJP's judgment.
Yeah. We're talking about the same judgment.
We're talking about the same judgment. And how that judgment, as your Lordship will remember, then related to the two SCA judgments, which are key to this. One being the Premier of the Western Cape judgment, the second one being the Bar Council, Cape Bar Council case.
So as I understood the decision in this court, it was that absence for a good reason wouldn't vitiate the proceeding.
Yes. Yeah, in a way, my Lord. Yeah. And
if you're ill, for example.
Yes.
And you have an alternate.
Yes, or you're stuck. Yeah. Someone who once said in the JSC that happens quite a lot, my Lord.
Yeah.
Now, so my Lord, the case really is about two concepts. You can have all these papers, but there's usually just one or two organizing concepts of a case. The organizing concepts of this case, my Lord, are two. One is interpretation. And by that, I mean interpretation of the court order, part of what Mr. Galan has done. The interpretation of Section 178 in particular. And the interpretation of the Bill of Rights, the fundamental rights that we invoke, including Section 19 and so on. But that's really what this case is about, is the interpretation first. The second one is the one your Lordship has just touched on, the second organizing principle. And I call it for shorthand again, unjustifiable exclusion. As we as lawyers know, unjustifiable enrichment. So we're creating a new topic called unjustifiable exclusion. If your Lordship is with us on those two issues, the interpretation and the unjustifiable exclusion issue, that's the end of this matter, my Lord. Now, let's go back to the interpretation point. And your Lordship, as your Lordship knows, sometimes it helps everyone, including the opponents and the court, to make it clear what we're not saying, rather than what we're saying, because we've been accused of all sorts of things, including wanting to collapse the whole system. My Lord, you will find from all the respondents that they make two fundamental mistakes about what we are saying, and I want to disclaim any of that up here. The one thing is that we are raising here the same arguments that were raised in the Western Cape High Court. That nothing could be further from the truth, my Lord. How could that even be, conceivably? That case, we were respondents being attacked by the applicants, or some of them at least. That's except Mr. Manager, right. And the issue there was a simple one, whether an interim interdict should be given against the self-same sitting and so on. So the issue which is before this court about the postponement or non-postponement of the JSC could not conceivably have arisen there at all. The second one, which is even more gutting, is that no, this is nothing but a backdoor appeal of the Western Cape Full Court judgment. My Lord, honestly, how could we, even if we were creative, seek that your Lordship here, by some measure, sitting alone, is going to overturn the judgment of the Western Cape High Court? It's impossible.
Well, I understand it to be common ground between the parties. The full court's order stands as
absolutely.
fact. The question is whether the JSC responded lawfully and rationally to that fact.
Thank you, my Lord.
And so the focus, that's why I put to Mr. Ngolwana, the focus must be on what the JSC ought to have done.
Absolutely.
Recognizing that it can't go behind that order,
yes, absolutely,
or criticize it in any way,
yes,
any more than I can.
Absolutely, my Lord. And more than I can. At least not here.
Yes.
No, thank you.
You should reserve your right to do
yes,
so when
I have to reserve my for the Western Cape High Court.
Yeah.
Thank you, my Lord. Then half of what I was going to say is done. And just in case there's anybody who has any doubt, my Lord, I want to say it here in public, that for the purposes of this court and the purposes of this application, this court has no option but to take that judgment as granted. Even if your Lordship read the judgment and said, I've never seen any judgment so bad, there's nothing you can do about it, there's nothing I can do about it, and there's nothing anyone can do about it.
So just on that point, can we clear up an ambiguity in the papers about the effect of the application for leave to appeal?
Yes, my Lord.
Is it your case that the filing of your application for leave to appeal suspended the operation of the order?
It is, my Lord.
Yeah.
And let me explain and how it fits into...
So while I must accept that it's a fact,
yes,
what you urge me to accept, that the order was final in effect,
yes,
and the filing of the application for leave to appeal suspended.
Yes, that's correct.
And the irrationality you impute to the JSC is that it just didn't appreciate
didn't recognize that fact, among other things. My Lord, your Lordship is making my job much easier. Let's go there, because that's the third interpretation point, as it were. I'll deal with it very quickly. What we are saying, my Lord, and this is again, I've dealt with this Section 18 things many times at different levels, and there are always these common problems around it. Remember, the difference between us and the respondents is that this is an 18-2 event, and we say it's an 18-1 event, as your Lordship just summed it up.
Yeah.
Now, these are the simple reasons we say it's an 18-1 event, my Lord, is your Lordship will find the actual wording of the, of the sections in our notice of motion and our funding of the, I think it's 02-6 60 something.
Yes, I have the act in front of me. You don't need
Oh,
to.
perfect. Okay, fine. Let me also just another do that here. So let's start at 18.2, my lord, and
Yes.
just read it together. So 18.2 says, subject, okay, the two things define whatever the default position is.
Yeah.
Subject to subsection 3, unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision that is an interlocutory order, not having the effect of a final judgment, which is the subject of an application for leave to appeal, is not suspended pending the decision of the application or appeal. Now, all we're saying, my lord, we concede that when we wrote the letter on Monday, this Monday, the applications for leave to appeal were not in. But we obviously indicated that they're coming, and as soon as they came, we sent them. In fact, I think, if I'm correct, subject to correction, by the time the JSC had its meeting, we had already lodged.
Yes, well, in its letter, the JSC refers to section 18.2.
Yes.
And so I think
So they must have, yes.
I think they must have
Yes,
appreciated that either their decision had to be taken on the basis that the appeal
Of
would definitely
18.2.
come, or that it had already come.
Absolutely.
Yeah.
As the court pleases, my lord. And I want to kill two birds with one stone, as we discussed this, my lord. The first bird is to answer your lordship's question as to why we're saying it's an 18.1, 18.2. The second one comes from what your lordship's remarks just now, which is why we assail the JSC decision on this point. In other words, we're saying on this point they made a material error of law. And as your lordship knows, material error of law leads to irrationality or illegality.
Well, if they made an error that's as basic as you say they did,
Yes.
then that definitely
That's
renders
it.
their decision
Yes,
irrational.
absolutely.
And there might be some highly complicated
Explanation,
terrain in
yeah.
which an error of law doesn't lead to irrationality,
Absolutely.
but I can accept for the purposes of this case it does.
Yes,
Yeah.
absolutely.
If there is such an error.
Yes, if a big if. Yes. Thank you, madam. Now, so since we're on the same page on that, my lord, let me then explain this in simple terms. So we say there are two exceptions which are contained in 18.2 that assist us in our interpretation.
Yeah.
The first is the word interlocutory order. A decision that is an interlocutory order.
Yeah.
Many people read that to mean an interim order. But that's not the same thing. Because as your lordship knows, there are interim orders and there are interim orders. And that has been explained in a case that I did called Libashe that everyone knows. I think it's the most recent.
The section itself appreciates that there may be interlocutory orders of final effect, because it only applies in circumstances
Absolutely.
where there's an interlocutory order not having
Absolutely.
the effect of a final
Absolutely.
effect.
Yes, and that's the second point.
Yeah.
So we're saying, my lord, forget about the final effect for a minute.
Yeah.
If it's not an interlocutory order, even if it had or didn't have final effect, that would favor us. But secondly, as your lordship let's assume we're wrong on the interlocutory order thing. If it has final effect, then it's excluded as well. Now, so we say on both legs, my lord, that favors us. And every lawyer, and I'm sure my learned friends will be no exception, will accept that if there's an application for leave to appeal and you can discount 18.2, then by default, then you are in 18.1.
Yeah.
So that's our argument. So our argument is simply this, my lord, that because of the operation of those two exceptions, we're in the 18.1 land. And once we're in the 18.1 land, contrary to what all our learned friends are saying, oh no, why, even on alternative relief, why don't you go to 18.3? No, it's them who should go to 18.3. They are the ones who have a duty, if they don't want to the order to be suspended, to do an 18.3 application. Thank you, my lord. I'm not going to belabor that one anymore.
Yeah.
I'm not saying
No,
that
I have the
agrees with
point.
me.
No, I have the point.
Yes.
Thank you.
Thank you, my lord. So that's a huge interpretational point on the one hand, but secondly, an attack on the reasoning process of the JSC. So I want to do it one by one. Now, my lord, if your lordship allows me to, then I'll do another double take to demonstrate to your lordship that what we are talking about, while accepting for the purpose of this, what your Lordship correctly called the fact of that order, that we accept. But what this case is all about is about the constitutional effect or the constitutional impact of that order. We're not attacking the order. We're simply saying its constitutional impact results in the JSC as matters currently stand being improperly constituted. That's really all. It's that simple.
And that's the second basis on which you attack
Yes.
the JSC's decision. You
Absolutely.
JSC ought to have appreciated that it be improperly constituted as it proceeded.
Yes, and if you look at their letter, my Lord, you will see
Yeah.
that actually is the main material error of law, as it were. For them,
they essentially say you're still Dr. Hlophe is still a member of the JSC.
So what's the problem?
He just can't come.
Exactly.
Yeah.
Well, that's what they're saying. Whereas, in reality, my Lord, if we are correct on this point of the constitutional impact, and let me, if your Lordship forgives me, let me just quickly get rid of no, I'll deal with it when we deal with the exclusion.
Yeah.
Let me stick to the constitutional impact. So if the constitutional impact of that valid order of the Western Cape High Court is to create an unconstitutional situation, a situation that is inconsistent with the Constitution. If I succeed in persuading your Lordship that the situation created is inconsistent with the Constitution, then your Lordship has no option, because Section 172(1)A says you must. Once I can show that constitutional inconsistency, your Lordship must declare that conduct to be unconstitutional.
Well, we get to the same result if I concluded that the JSC had acted irrationally.
Yes. No. Actually, my Lord,
that would be in breach of Section 1C.
Absolutely. In fact, my Lord, and I'm glad your Lordship asked that question, because again, it's misunderstood. That's the difference between Section 38 of the Constitution and 172. The Lordship has hit the nail on the head. Some people confuse the two. Section 38 deals with an infringement or threatened violation of a right in the Bill of Rights, right? But Section 172(1)A, as your Lordship has correctly summed up, deals with the inconsistency with the Constitution, not just with the Bill of Rights. So any section of it, So that's the difference which is usually misunderstood. And your Lordship is 100% right. Whether it's Section 1C or Section 200 or Section 300 or whatever, if you are able to
I'm just trying to work out whether there is a Section 300.
Good. No, Lordship is definitely on point. But I'm exaggerating for effect.
Yes.
So I'm saying, my Lord, whatever section of the Constitution is violated, or once that is established, of course, that's the gateway. Once that is established, then and the constitutional writers, my Lord, were it was a deliberate way to phrase 172(1)A as opposed to 172(1)B, because that's what constitutional supremacy is. We can't say the Constitution is supreme, and then we say a court has a discretion.
Well, it seems to me the 172 duty is to declare any conduct that is inconsistent with the Constitution to be so.
Absolutely.
But then there's a wide remedial discussion about what a court does.
What to do, yes. Yeah. In fact, sometimes a court may do nothing.
Yeah.
but what a court is enjoined to do constitutionally, it's a duty, a constitutional duty, is once established, it must declare.
Yeah.
And that has been said, my Lord, if you had the Lordship allow me 1 minute to digress as to why that is so. One is constitutional supremacy, we've dealt with that.
Yeah.
But the second one, which is always forgotten, is something called the doctrine of objective constitutionality. Now, that's just a lot of big English. But what it really means, my Lord, is that when the court does that and makes that declaration, it is not declaring the conduct of the JSC to have been unconstitutional last week or on Tuesday when it had a meeting. It's declaring that that conduct is unconstitutional since 1996.
Yes.
That's so it's...
Unless the retrospectivity is...
Absolutely, yes. Yeah. That's why sometimes the court then ameliorates that, yes. So it is that serious. That's why we have something, another misunderstood concept called the Gijima principle. And it goes like this. Once a court has a 172.1a issue in front of it, it must, even in the face of unreasonable delay, in the face of mootness, and all these other niceties, that court, according to the Gijima principle, still has to grant the order. Why? Because all these niceties notwithstanding, a court cannot go back to chambers to put it, to demonstrate it, and leave an unconstitutionality sitting on the table, simply because it took me 6 months or whatever. It's that serious, because that implicates the supremacy of the Constitution. Now, that then puts a burden on me, my lord, to convince your lordship that there is indeed an inconsistency with the Constitution. Not in the full court, in the conduct of the JSC, yes.
And so, the two points you've made so far are that the JSC misconstrued the effect of the order, and that it misconstrued the impact
of Section 18
of excluding Dr. Hlophe from the proceedings.
Yes.
Is there any further point?
Yes, and Section 18, you remember we just discussed.
But doesn't that really collapse back into final or interlocutory effect of the order? If the JSC thought that the order was interlocutory in effect when it was only final, when it was actually final in effect, it doesn't. The issue about whether 18.2 or 18.1 or 18.3 apply falls into that misconception, doesn't it?
No, my lord, with the greatest respect. It's much more serious than that. It is that, of course, but it's more serious than that. It has two serious impacts. It says that the JSC, when it was given, remember the JSC is an organ of state. So
the better way to put it, sorry to interrupt you, but the better way to put it is your case is that the JSC failed to appreciate that the order was suspended by the application of leave to appeal.
And in doing so, as we discussed earlier, committed a material error of law. And if the JSC's decision is irrational, then the lordship has no option but to...
And then there's the constitutional impact of proceeding in Dr. Hlophe's absence. Is there anything else that in your submission vitiated the rationality of the JSC's decision?
Yes. Yes, my lord. Okay, let me put it this way, my lord. If your lordship allows me, I won't answer the question directly. I just want to start at the end. One of the giveaways, and we say this, unfortunately, your lordship isn't in our reply, but your lordship will find in our reply that one of the things we say is that one of the giveaways that the JSC's decision was irrational is something that is said by one of its commissioners, Mr. Nfaitobi, in his supporting affidavit.
Yes.
In that, he actually says, my lord, let's find that in section 6, page. Anyway. Let me paraphrase to save time. Your lordship will take a lordship there. But this is
I have it here. It's 06-287.
That's 287.
Yeah.
Yes, ma'am. All right. I'll get to it. Let me just paraphrase. Your lordship will read it well, there's no good time. I was going to say good time. Unfortunately.
No, but I have already read it.
Yes.
So if you just refer to the part of it, just while we're on this point. I still don't see the replying affidavit on case lines. If someone on your team could sort that out.
Yes, Martin is